Hi everyone. Good afternoon. My name is Eden Sarid. I'm a lecturer here at the School of Law in College London. My pleasure to extend a very warm welcome to Kings to all of you to our book symposium. I'm Dr. Haim Abraham, to book Tort Liability Warfare, Stay Strong in Civilians' Rights. We're fortunate to have a brilliant lineup of speakers today, each of whom brings a wealth of expertise to this important discussion. We have Professor Moffett from Queen's University Belfast, who's an expert in reparations, human rights law, international humanitarian law, and transitional justice. Professor Paula Giliker from the University of Bristol, who's an expert in comparative tort law, comparative tort law, and contract law. Professor Zegveld from the University of Amsterdam, who's an expert in liability for human rights violations, with a particular focus on victims of war and their access to justice. Professor Ugljesa from University College London, Grusic, from University College London, who is an expert in the interplay between private international law and human rights, especially in tort claims arising from external exercise of executive authority and civil claims against multinational corporations for human rights violations. And the man of the hour, Dr. Haim Abraham from University College London, who is an expert in tort law, the philosophy of law, critical legal theory, and the author of the book we're going to discuss today. And I think with such an exceptional panel, I'm confident we're in for a fascinating and thought-provoking discussion. Before we begin, just a very quick housekeeping notes. Women's toilets are on the second floor, so one floor up from here, while men's general neutral and accessible toilets are at the end of the corridor. Note that Somerset House doors lock automatically. They're supposed to be disabled, but there are little stoppers at the door, so just don't remove them so people can walk in and out. And following the discussion, we'll have a drinks reception in the adjacent room right there on your back. Lastly, I want to extend our thanks to the Yeoh Tiong Lay Centre for Politics, Philosophy, and Law here at King's College and UCL's private law group for their generous support of this event. And a special thank you as well to the wonderful events team here at King's, particularly Ms. Shauna Creamer for her assistance in organizing today's symposium. Thank you all for joining. I hope you enjoyed what promises to be a great evening. And now to you. Thank you very much.
Thank you. And thank you for inviting me and organising this. It's a pleasure to be here today. I've got a bit of a cold. My toddler is just like a typhoid Mary, so it's just infecting everybody. So I hope I give you the cold. My comments will be quite short. I'm going to sort of moderate part of the discussion. What I wanted to do is maybe set the book in the broader context of international law and war and reparations. I think this book is really exciting, and it's also open access. So like it's very rare you get a good book that's also free. So I would encourage you if you have time to read it. Like where I see the origin story of redress and reparations in international law is nearly set 100 years ago. But the Torzo factory, a factory dispute between Poland and Germany after the First World War. And there was no real international law of reparations. And so where arbitrators and judges turned to was private law. And so the origin story of redress and reparations in international law is with tort and private law claims. And the Torzo factory sets down this famous dictum of that where there's an international wrongful act by a state, it has an obligation to make reparations for that harm, to remedy the harms caused. That's where the good story sort of ends, because where this position is set up in international law is that states have the right to reparations and states have the right to compensation. And so the fundamental flaw that we have when it comes to armed conflict is that civilians don't have an explicit right within the laws of war, international humanitarian law, to seek redress, to seek reparations. And this seems strange. You know, we're 75 years after the Geneva Conventions, we're 80 years after the UN was established, and yet we still haven't established a legal framework where civilians have a right to redress for the harm that they've caused. And so Haim's book here encapsulates, it's almost like a gap that's existed for a long time, particularly in common law, to recognise that civilians do have rights when it comes to war. And that's what we've often seen with states after the Vietnam War, the Second World War, even the Falklands War, is that states wave away any sort of claims that civilians can get. And this is still an issue between Germany and Italy when it comes to the Second World War, and it's a fundamental issue when it comes to Russia and Ukraine, which I'll touch about in a second. And so the international legal position leaves civilians with no avenue for redress. It leaves them out in the cold when it comes to law. And so this is where this book becomes really novel, because it goes back to the origin story of redress in international law by looking at private law. Can private law offer a tort where civilians have rights? And I think this is where Haim makes really some really good inroads. And I think the book's it's good. I wouldn't be here otherwise. But it's innovative and it's forceful. There's some really good deductive reasoning where the naysayers say well, victims and civilians in war don't have a right to redress. You sort of knock them back, and you sort of expound this tort for belligerent wrongs. But things like rights exist and are relevant within war, and individuals do not lose their rights, and that accepting sort of lesser forms through like sort of charity payments to the state or insurance claims, it comes at too high a cost for civilians' rights. And so as a human rights lawyer, for a long time we've been trying to incorporate human rights law into armed conflict and establish that victims have a right to reparations, and it hasn't gone that far. There's been a few cases, but taking a step back and going back to private law is. It seems obvious now that you've written the book, but I think from the common law perspective, we've went to international law as the source of trying to change the way in which international law deals with civilians and warfare, and we haven't got that far. And so this book, I think, really makes an important contribution. I don't mean like a sort of theoretical perspective of the possibility of rights. This is an issue before the Ukrainian Supreme Court at the moment, where they've sort of expanded the territorial tort exception to state immunity by allowing civilian victims in Ukraine to sue the Russian state. Even though they don't have authority over Russia, because of the nature of aggression, they've extended this. So it changes the way in which international law is domestically understood there. It probably will end up Ukraine losing a case at the International Court of Justice. An easier way would be to suggest what this book does, is to look at how the state itself can seek and to remedy its own citizens, how the Ukrainian government can offer private torts and avenues of redress to civilian victims, and then claim the final bill off Russia. And this is not to endorse Donald Trump in any way, that there's an art of the deal here or anything, but I think at the end of conflict, there does have to be some sort of accounting. And in the meantime, having a private legal avenue for civilians who have suffered harm, in particular, belligerent wrongs here, is key into ensuring that civilians' lives matter in war. So I'm excited to hear from my colleagues on this panel. I'm not going to speak too long, thankfully. Somebody will talk about the tort perspective and the tort contribution to this. Liesbeth, who's like one of the world's leading litigators against the Dutch military, we've been around case law in this area, will be also speaking. And I think for those who are interested in this area, who are students, who are practitioners, academics, this book has the potential to be, going beyond how we domestically teach tort law, private law in this country, to think about, a new generation of scholars can work around extending private law into the international sphere and dealing with the sort of the lawless state that is wartime. So I'm delighted to have this panel to speak to you today. We are going to go through each person speaking for about 10, 15, 20 minutes each, and then there'll be a short response. So thank you for your attention, and I'll pass over to Paula now.
Thank you, and thank you for the invitation to be here and the opportunity to read and reflect on Haim's book, which I also strongly recommend reading, not just because it's free, but because it's a very good book, which I think perhaps is a bit more important. My remit is focusing on tort law, and I really want to think about the tort law arguments and also how it's likely to be received by the tort law community. This does not mean that this is how I would look at it, but I think we need to look at it in the broader context. I also want to focus on the chapter, this is a surprise, nobody who knows me, on vicarious liability and non-local duties, and finally focus on your use of comparative law, because I think what is interesting about this book is its use of how it uses comparative law and how it implements the ideas and sources from these jurisdictions to embellish and enrich the discussion and the normative framework that does result. From a tort law perspective, this is, I think, a fascinating book, mainly because when I was taught law and when I write about tort law in a textbook, the assumption that one has is that it would be inappropriate to impose private law liability on the battlefield. So from a UK perspective, until 1987, Section 10 of the Crown Proceeding Act 1947 awarded the Crown a statutory immunity in respect to deaths or injuries involving the armed forces. So for tort lawyers, the one thing we do learn are that it's a bad idea to have liability in relation to the battlefield. So if we look at Mulcahy, which is a leading authority on this, so Ian Glidewell argued that public policy does require that when two or more members of the armed forces of the Crown are engaged in the course of hostilities, one is under no duty of care to another. Indeed, it could be highly detrimental to the conduct of military operations if each soldier had to be conscious that even in the heat of battle, he owed such a duty to his comrade. If during the course of hostilities, no duty of care is owed by a member of the armed forces to civilians or their property, it must be even more apparent that no such duty is owed to another member of the armed forces. So notice that premise that the starting point is you do not owe a duty to civilians, so therefore you cannot owe a duty to fellow soldiers. And this was taken from, as Haim says in the book, from the Australian case of Shaw, Saville and Albion. And again, you have a highly respected Australian judge, Justice Dixon, saying that it would be completely inappropriate to have a duty of care, tort liability, in the theatre of operations. So if we look at what the common law jurisdictions have done, they have narrowed what they call combat immunity. But again, one gets the repetition that combat immunity does have a fundamental basis in the law of tort. So again, drawing on a UK authority, Smith and Ministry of Defence, Lord Hope in that case identifies 4 concerns that he has that must be taken on board if we're going to have tort law liability in this context. He says we must look at the context. Close attention must be paid to the time when the alleged failure has taken place, the circumstances and the persons by which decisions were made, the extent to which the alleged tortfeasor had been constrained by decisions previously taken by others for reasons of policy. Is this an area that's actually justiciable? The extent to which the alleged tortfeasor has been constrained by the effects of contact with the enemy. And this I would emphasise, great care would need to be taken not to subject those responsible to duties that are unrealistic or excessively burdensome. So this is the windmill at which Haim is effectively tilting. The idea that these assumptions we've been taught, we must question them. Why is that the case? How can we say that this is an unquestionable premise on which we should address the law of tort? And what's interesting is that to tilt at this windmill, he looks from a perspective of corrective justice, but also in the context of international humanitarian laws, the rules of engagement, and substantive rule of law. Looking at those collectively, he argues that non-combatants or civilians should be able to bring a claim against the relevant state if injured by belligerent wrongdoing. So it's a narrow form of liability. Belligerent wrongdoing, you're told, signifies violations of ordinary private law rights that are inflicted while infringing international humanitarian law and the rules of engagement. Corrective justice, he submits, allows us to identify norms, even in the most extreme and difficult times. And I think that is a key element, that we're actually looking at tort liability in the light of international humanitarian law and the state's rules of engagement. So we're not looking at a conventional view of tort law, but a very specific way of looking at tort law in this particular context. And to quote him at page 55, as liability would only be imposed for infringing the international humanitarian law and rules of engagement, rational combatants should not be over-deterred from taking actions that adhere to these principles. So one of the key arguments has been we do not want our soldiers consulting with lawyers before they go onto the battlefield. They will be inhibited, they'll be over-deterred by liability. And in his book, he argues that this over-deterrence argument is assumption that is flawed and needs to be challenged. And it's interesting to me because one of the things I've done in my own research is actually looked at the interrelationship between tort law, core tort law principles, and the interrelationship with, say, EU or human rights law. To what extent, when we're looking at the tort of negligence, should we integrate ideas of human rights which shape a framework that is legally and morally just? This view, however, has had some opposition from those who regard tort law in a more purist sense. And I have to say, some of these are corrective justice advocates. So they would argue that if we're looking at the integrity of domestic tort law, to what extent legitimately can you bring in external ideas? Lord Bingham, however, author of The Rule of Law, which again you mentioned in your book, argues that what we need in a law of tort is evolution. It must develop, he argues, analogically and incrementally so as to fashion appropriate remedies to contemporary problems rather than remaining static. This, I would argue, is what Haim is saying in his book. But of course, the problem with that argument that Lord Bingham found is that this idea of, in a sense, gold plating existing tort law rights is something that the current UK Supreme Court is resisting. In another Smith case, Smith and Chief Constable of Sussex Police, Lord Brand advised, "Your Lordship should not feel tempted to develop the common law in harmony with convention rights. Convention claims are very different objectives from civil actions. Clearly, violation of fundamental rights is a very serious thing, but I see no sound reason, however, for matching this with a common law claim also." And it's interesting when he says that, he draws on the fact that liability can lead to over-deterrence, and also there are other ex gratia schemes that you could use. And again, Haim in his book hits those arguments and explains why you do not regard them as sufficient. But my one comment here would be that there is going to be opposition to this for tort lawyers, and therefore what we need them to do is read this. But my comment here, will Haim's novel thesis prove too novel for traditional domestic lawyers? So again, that's one question I wanted to raise. My second point is on vicarious liability and non-negligent duties. And as anybody who knows me knows, I had to restrain myself from going straight to chapter 6 and actually read the earlier chapters before getting onto this. And it is, as you might expect, extremely thoughtful and well-researched chapter that raises, I think, really interesting questions about how we take, particularly vicarious liability, this framework developed over hundreds of years, this idea that you have a relationship, usually employment, the tortfeasor commits the tort in the course of that employment, and then you are held responsible, and how we adjust that to the particular context of combat. And what I find interesting is that one of the tensions we have at the moment in tort law and vicarious liability is in relation to, for example, institutional sexual abuse cases, again taking general principles and putting them in this particular context. So I think you do address this, but it's interesting to see that obviously the one question would be the relationship. Is it one of employment? Where does that leave contractors or civilians? And the one point that came too late for the book is the fact that in Australia at the moment, we see a very narrow view of vicarious liability in which you must have an employment contract. So this idea of akin to employment has been rejected by Australia. And also in the UK, we see through BXB a narrowing of vicarious liability. What's interesting about both those cases is that they related to sexual abuse, which you might think there's policy reasons why something needs to be done, and yet they're adopting a more purist approach. And that comes to a question I wanted to raise with you, which is when you're looking at the course of employment test, you focus on negligent wrongs, and your treatment of intentional wrongs is somewhat equivocal. So just to quote you, if I may, the applicability of vicarious liability to intentional torts across jurisdictions is not sufficiently unified and consistent to be able to make a claim in relation to intentional belligerent torts. It could only be established in this context on a case-by-case basis, looking at a range of factors in each instance. There's nothing unique in intentional infliction of a loss through competence activities that suggests vicarious liability should be altogether inapplicable in the context of warfare. So you say it can apply to intentional tort, but it's not clear to what extent. And coming from my background looking at vicarious liability in the sexual abuse context, we know that rape and sexual violence is used in the course of warfare. We know that it's used as a way of dealing with civilian populations. So I'd be very interested to know to what extent the concept of vicarious liability you have in chapter 6 would be applicable in that context. To me, non-delegable duties seem to work better here, because what the advantage of non-delegable duties, and the reason that it's been argued by many commentators that in relation to sexual abuse, non-delegable duties work better, is they focus on the specific scenario. They focus on the vulnerabilities, the abuse of trust, the relationship between the state and the victim in this context, and one can shape them to deal with specific issues. So I think quite persuasively you argue in favour of non-delegable duty to ensure the health and safety of prisoners of war. And we can draw analogies here with non-delegable duties on prisons and in relation to vulnerable prisoners. So again, we can see the specificity of that leads it to this particular context, and the idea that in this book you're dealing with belligerent wrongs, you're dealing with a specific context. Your other non-delegable duties in relation to ensure occupied populations do not sustain belligerent wrongs, and more broadly that all civilians do not sustain belligerent wrongs. I do wonder whether they are too widely framed again to be acceptable. And I think one interesting thing you raise is that if it doesn't work in tort law, could it work under international law? And I think that comparison is a really, really interesting one. Finally, I want to talk about comparative law. Comparative law is a big part of this monograph, and Haim looks at mainly common law jurisdictions, England and Wales, Australia, Canada, the US, but also Israel as a mixed jurisdiction. And if you think, well, why is Israel there as a mixed jurisdiction? It's because Haim is clearly an expert on this jurisdiction, but also, and I think rather sadly, it does give us a ready source of problems and examples and cases. So it's a really useful source to actually look at what's happening in real life, the litigation, how one addresses this, and the state's response. So it does fit within the remit, even though it's not a purely common law jurisdiction. But from a comparative law point of view, it's not a traditional comparative law book in the sense that we're not getting, it's Israeli law, it's English law. What you're using is comparative law as a launching pad to address general principles. And I think that is what's really interesting. Using these as sources, using these as material to be critically sifted and appraised in the light of academic commentary. So comparative law here is used as a launching pad for setting up a normative framework. And I think that's a really interesting and valuable use of comparative law. To quote Uwe Tischl, for comparative lawyers, important fields of research are not just law in books and law in action, but also internal disagreements and debates, schools of thought and contradictions, law in debates. And I think this is what the book gives us, law in debates. And I think that is what is particularly valuable in making us think, making us question, as I said at the start, the assumptions we learn in law school that this is a no-go area for tort. It's actually forcing us to readdress that with a very strong argument in favour of some form of private liability. So reading this book, I don't think anyone could doubt Haim's immense commitment to this project, and it's resulted in an outstanding monograph, which is challenging, controversial, and, it goes without saying, expertly researched. To me, the sticking point for tort lawyers is going to be Lord Hope's final concern that great care needs to be taken not to subject those responsible to duties that are unrealistic or excessively burdensome. And Smith and Ministry of Defence, when it came out, had a huge backlash from the military community, from certain newspapers and certain commentators, that this was lawyers being unrealistic and imposing burdens on our military, which are not helpful and will actually put a burden on them that will actually diminish their military efficiency. But to me, the fact there's predictable opposition, the important thing is it doesn't shape our academic endeavour. Rather, in my view, I would argue it increases the importance of books like this that give us counter-arguments for change based here on humanitarian commitments and the rule of law. This is a stimulating and significant work which I really hope will be read by tort lawyers, judges, and politicians alike. Thank you.
Thank you. Or maybe I'm the unrealistic one here. A bit of stranger here, coming from a civil law country. Pleased to be here. I read the book and I thought, am I missing something? We're already doing this for the last 3 decades or so. Why is there nothing in there about civil law countries? But I understand this is the common law world, and I hope to give a different kind of perspective on it. I'm a practicing lawyer in Amsterdam. I'm also affiliated to the University of Amsterdam. My original background is international law. So what I did at some point is starting to use private law for what I felt would be right. That's implementation of humanitarian law, the laws of war through private law, not aware that I was doing something that was normal. I just thought, I'd just give it a try. I didn't even realize. Now I realized that it was quite, quite a leap that we took. I worked, after my PhD, I worked with Professor Kalshoven on constraints of the waging of war, which was an ICRC handbook on the laws of war. And it was the 3rd edition, and I was, he asked me to assist. And I said, where's the chapter on enforcement? And he said, there's no chapter, there's no enforcement, basically what he said. He said it's the oldest law in the world, originating from end of the 19th century. But states never wanted a real mechanism for enforcement, for supervision. It struck me as strange. I defended my PhD, and one of the professors coming from, again, a different background, not humanitarian or human rights law, said, it was about internal armed conflict, and he said, who's going to enforce all these rules? It's a nice PhD, but who's going to enforce this? And I said, yeah, good point. And that's where I started my practice. So we even at some point proposed, it was 25 years ago, I wouldn't dare to try it again now, to set up a kind of an individual complaints committee under the Geneva Conventions and the additional protocols, because I thought, if it works in human rights law, why wouldn't it work in humanitarian law? What's the huge difference? We worked on it for a few years, wrote articles about it. Of course, it was never going to happen. And in any case, also human rights procedures that end up at the international level would have to go through domestic remedies, of course. So you would still need domestic courts. So why not begin then in the domestic courts? And that's what we did. It's not that we didn't face any problems, to say the least. And these problems I do recognize in this book. So, and I'll take you through some of the cases and some of the problems that we have been confronted with over the last 25 years. And I'll do so by taking on 3 cases. I thought of the Srebrenica case, which is a peacekeeping operation in which Dutch was involved, and many other militaries, by the way, Canada, Australia, I believe. And then a case on bombardment in Afghanistan, in Chura, in Uruzgan in 2007, which was only concluded recently, and we're still working on the compensation to get it actually over there, which is a problem in and of itself. And then finally, the coalition war against IS in Iraq, in which the Dutch have been involved with 16 other coalition countries. Just briefly. Okay, the case that's really changed my perspective was the case of Srebrenica. And it was as I said, of course, the International Court of Justice ruled that it was concerned in the end of a genocide on 8,000 men, the Bosnian Muslim men who fled to the safe area, Srebrenica. It was attacked by the Bosnian Serbs, and the civilians fled to the United Nations complex. The 3rd Dutch Battalion was stationed there. And they were, as most of us may know, they were pushed out of this compound into the Bosnian Serb hands. And all the men, mostly there were women and children, but the men who were inside the compound, were 5,000 people inside the compound, were 270 men, and the men were all murdered, men and the older boys. One of them was the interpreter, the UN interpreter for Dutch, Hassan Ohanovic. His parents, his brother were killed, and he was safe because he had a UN permit. And he said, looking for justice, searching for justice, he went to the US, he went to the UK. Now I understand he was pushed away, saying, "Oh, we can't do anything for you." And he ended up in The Hague. And he said, okay, there were two flags on the UN compound. There was a UN flag and there was a Dutch flag. And my parents and my brother went at the very last moment through Dutch soldiers' hands. So why not hold the Dutch responsible, the state of the Netherlands? I just finished my PhD and I thought, having no knowledge of private law whatsoever, I thought we just begin. We lost in first instance on the basis of the argument that it was a United Nations mission. And UN, of course, has international immunity, which is different from the state immunity that you may have here within the borders. But then in appeal and also the Supreme Court, it was decided that the Netherlands could be held responsible on the basis of dual attribution of the acts by the Dutch soldiers wearing both a blue helmet and a green helmet. And it said, well, at the very last moments, our government took over in an effort to get our soldiers back home. And so who was in effective control over there? It was really also, at least also, leaving aside UN, the Dutch government. And it was based on Bosnian tort law. It was based on human rights law because we had jurisdiction over the compound there. This tort law concept changed later. At some point when we continued our practice, the courts found that it was not very acceptable that to our military foreign tort law would apply. So a new rule was established thanks to this practice, I'm afraid, saying that Dutch law would continue to apply wherever the military go. That was after Srebrenica, but in this case, we applied Bosnian tort law. The state, I won't go into details of Bosnian tort law because it won't be very interesting, I think, here. I think that some of the arguments that the state put forward are interesting in view of your book. And it said to the courts, and that was, I think, before the Supreme Court, that the court should take account of the need of judicial restraint in its review of what happens. I think it's one of the avoiding doctrines that we have, that this is, that we should be aware of the politics, the military reality, and scaring the court out of this war domain. But the Supreme Court found, and I quote Supreme Court, that there's no basis for the exercise of judicial restraint. There's my text here somewhere. I don't know why this happens. And since it's a quote, it makes it a little bit. Just go back. Yeah, there I am again. Is that the right text? Yeah, should be. Yeah, sorry for that. Go back to the quote. There's no basis for the exercise of judicial restraint of this kind, as it cannot be found in unwritten international law, in the European Convention, or the International Covenant on Civil and Political Rights, or indeed in domestic law. I have to apologize because something goes wrong that he keeps switching to a different text. But I may want to do it on this basis. It's fine, I think. And it found that such exercise of judicial restraint would mean that there would be virtually no scope for the courts to assess the consequences of the conduct of a troop contingent in the context of a peace mission. So that goes quite far. Now, the state put forward a second argument, and it said, and it's basically kind of a threat when we were litigating in pleadings the case in the Supreme Court, and the state said that this case would have an adverse effect on the implementation of peace operations by the United Nations, in particular on the willingness of member states to provide troops for such operations. I responded, if this is the way you do it, you better stay at home. But the Supreme Court also responded, and it said that this should not, after all, prevent the possibility of judicial assessment in retrospect of the conduct of the relevant troop contingent. The court should indeed make allowance for the fact that this concerns decisions under great pressure in a war situation, but this is not something that has been disregarded by the Court of Appeal. So we do not recognize combatant immunity, but also concepts like foreign interest or the political doctrine theory we don't have in our jurisdiction. And the case changed how we view justiciability of rights and duties in situation of armed conflicts. And from there, we moved on and slowly started to more directly invoke humanitarian law. Not directly, we couldn't, as it doesn't state clear rights, as was already said, and I come to that. Does humanitarian law provide for rights? It's of course a question that you address as well. Under Dutch law, unfortunately, and there we are on the same page, the answer is still no. Our courts do still reject the provision's self-executiveness. But we circumvented this by inserting humanitarian law in the duty of care, laid down in our civil codes, and the standard of care is indeed, as this study also rightly claims, inferred from humanitarian law norms. So that's the way how we invoke humanitarian law norms. Now, by way of example, a case that we litigated on Afghanistan, it was a bombardment of on an Afghan Kala, it's a walled residential complex, during the Battle for Chora in mid-2007. The village was suspected of harboring Taliban fighters, and it was bombed, and some 100 people were killed, and all the houses were destroyed. There was one family, and they always may wonder, how do they come to us? They generally come to us through investigative journalists. And one family that lost 20 members asked us to sue the Dutch state for the bombardment. As I said, by then, the applicable law was Dutch law, and the specific norm applied by the court was the duty of care. And the duty of care enshrines what is generally accepted according to unwritten law. We could also have evoked the infringement of a right or statutory obligation, but I feel that we're still not there in terms of the conversation about whether rights are laid down in humanitarian law. The leading question in that case, and that's interesting, was whether the duty to distinguish between civilian and military objects was implemented, whether proportionality principle was obeyed. The principle applied, or the standard applied by the court, was that of the reasonable commander. You wrote quite extensively also about reasonableness. And the reasonable commander is derived from the case law of the European Court of Human Rights, the case of Hanan versus Germany. We argued that the bombardment breached this principle of distinction, that the Kala in which the family lived was a civilian object and could only have been bombed if it was or could have been considered to be a military target. And the court concluded 2 years ago that, and I quote, the state did not substantiate concretely enough that the state could designate this Kala as a military target. As a result, the bombardment of this Kala must be considered to be unlawful. And the Netherlands was responsible and had to pay, still in the process of paying compensation. Okay, I'll skip this part. I must say, had it been for rights, if we could have argued that rights like human standards, right standards would have been violated, we would have I think, a stronger case. So it's still important that humanitarian law is still behind the field of the duty of care. Still remains a balancing of interest, which would not be possible if we could invoke human rights standards. Okay, I have 2 points for consideration very briefly. Is that I think that your book is mainly about Hague law within humanitarian law and not so much Geneva law, and that within humanitarian law you could distinguish between, on the one hand, the rights of individuals, though it's all humanitarian law, and you could argue that it's all distinct from human rights law. But I think the active combat poses the biggest problem, rather than detention situations, torture. Srebrenica, for example, you could compare it perhaps with a detention situation, rather being on a compound. Also the Abu Ghraib detention situations, maybe less difficult to litigate. That's one comment that I have, and which we're confronted with in practice, that these cases of actual combat are much more difficult. The second one is, if you allow me, is that I agree that actual combat it's difficult to litigate, but then if we now look at the current warfare, where there's much more remote air warfare, for example, the war against IS, the target determination is done in Texas, and the actual decision making by the pilots once they are above a specific target is close to zero. They basically implementing what's decided in the US. I was wondering, in view of this book, whether that doesn't close much of the gap between lawfare and ordinary torts, in the sense that it's not so much anymore the heat of the fight, the split-second decision making, but actually something that's been decided and prepared for weeks ahead. And then all we do is press a button and we kill like hundreds. Hadija, we're now in the midst of that case, 100 to 200 people. Is that so difficult for soldiers? Is that something that's, that they said, well, we had to decide in a split second? Thank you.
Thank you so much. First of all, I would like to congratulate Haim for writing what I think is a really wonderful book. I would like to thank Haim and Eden for inviting me to talk today. When I finished reading the book, the first thought that crossed my mind was, I really wish this had been published maybe 2 or 3 years earlier, whilst I was writing my book on torts in UK foreign relations, because I think it would have saved around half year of research for me, at least half year. So Haim presents not only a really good argument in favor of application of international humanitarian law and rules of engagement in a tort law context, but he also actually presents a really good map of how tort law should work and what are the key elements of tort law if it were to operate fully in this particular context. So I would like to congratulate you for writing so clearly and also so persuasively. I suppose today I will talk about Haim's book from the perspective of a private international lawyer who dabbles a little bit in foreign relations law. And one thing that I would like to explain is something that was basically the starting question after I read the book for me, which is, well, what actually needs to change in English law in order for Haim's approach to be implemented? Now, Haim takes a comparative approach in his book. He basically writes not only about English law, he also writes about Australian law and Canadian law and New Zealand law and US law and the law of Israel. So he's not really interested in sui generis solutions that exist within these systems. He adopts a more theoretical approach, a more abstract and general comparative law approach. But nevertheless, I would like to look into some of the doctrines that we have in English law, because I think there are some nuances here that could be quite helpful for advancing this project even further. So in order to answer the question, what changes would be needed in English law to implement Haim's approach, I think we need to firstly look at what are the key elements of Haim's proposal, and then we need to look at the key elements of the English approach to these kinds of claims. And then we obviously need to see what needs to be changed in order for Haim's approach to be implemented. If I read the book correctly, I think there are 4 key elements to Haim's approach. So firstly, he adopts 3 different frameworks to analyze, to answer the research questions. And these frameworks are international humanitarian law and rules of engagement, a corrective justice approach to tort liability, and a substantive rule of law approach that he uses to dismantle some existing doctrines and defenses in this field. The second element of Haim's approach is that international humanitarian law and the rules of engagement are basically used to differentiate between lawful and or wrongful and non-wrongful losses that are inflicted on civilians during combat. The third element is that the approach is targeted at what is the most difficult question, which is the application of tort law to what happens in the heat of battle. So the scope of Haim's book is limited to belligerent wrongs, and he's mainly interested in dismantling what he calls combatant activities exception, or what is otherwise known in this jurisdiction as combat immunity doctrine. And then finally, the fourth point, the fourth key element of Haim's book is that the courts of the state that is being sued should be open to these kinds of claims. And he also says the choice of law is not really a material question here, because it doesn't really matter if we apply foreign law or foreign law, as long as these laws, all relevant laws, implement this proposed approach. Now, let's compare the key elements of Haim's approach with how we deal with these kinds of torts here in the UK. And in the UK, we do have quite a lot of cases where the UK government was sued for, generally speaking, wrongful exercises of sovereign authority. Not only claims that concern what happens in the heat of battle, but also claims that concern, for example, mistreatment of prisoners who are captured in war zone. We have also cases that concern torturing of people following sharing of intelligence with foreign powers, and so on. And I would say that there are 4 key elements to the English approach. So firstly, English courts do have personal jurisdiction over the UK government and UK government officials. So personal jurisdiction is not really a problem here. What is a problem is basically the grounds of claim that can be advanced against the UK government as a defendant. So we have the common law rule that the king can do no wrong, which means that the central government at common law cannot be liable in court, either directly or vicariously. Now, this rule has been changed in 1947 with the passing of the Crown Proceedings Act. However, the Crown Proceedings Act allows for vicarious liability and only 3 grounds of direct tort liability, which are breach of employer's duties, occupier's duties, and statutory duties, which are binding on private parties. So the scope of direct liability of the central government in this country is extremely limited, and I think not particularly suited for the kinds of claims that Haim has in mind, which is mainly the direct liability of the state. A third key element of the English approach is that we have several preclusionary doctrines and defenses that operate in this field. One of them is the combat immunity doctrine that has already been mentioned. But another doctrine which is very, very important and influential is the Crown Act of State doctrine. Now, if the government sends soldiers to operate in a foreign country, and those soldiers injure, let's say, a foreign civilian, basically both doctrines operate in this field and shield the government from responsibility. So the combat immunity doctrine operates, and it is derived from basically the prerogative to wage war. But then you also have the Crown Act of State doctrine, which is derived from the prerogative to engage in foreign relations. And even if we were to dismantle the combat immunity doctrine, I think we still need to deal with the Crown Act of State doctrine, because it is still there. It operates in exactly the same field. And then the third element of tort liability in this country is that choice of law is actually very important. So if you sue the UK government for something that happened in a foreign country, if you manage to pass the obstacles of combat immunity doctrine, Crown Act of State doctrine, and related preclusionary doctrines and defenses, the English courts will usually apply foreign law, that is the law of Iraq or the law of Afghanistan, to determine on the tort liability of the UK government. So if we compare Haim's approach and if we compare what we have in the UK, there are actually three things that need to be attacked, if you will, to implement Haim's approach. So the first one is we should argue in favor of more bases of direct liability. We should try to dismantle not only the combat immunity doctrine, but also the Crown Act of State doctrine. And finally, I think choice of law here presents a bit of a problem because I do think it's problematic to determine on the liability of the UK government on the basis of, let's say, Iraqi law or Afghani law. Now, I don't think I have time to talk about all of these things, but I would like to focus. I'm only allocated 10 minutes. Okay, so if I may, I would just very briefly like to comment on the preclusionary doctrines and defenses that operate in this field. If we focus on warfare, so what happens during warfare and combat, and if we only focus on the combatant activities exception, I think we leave outside the scope cases like the well-known Al-Siran case in this jurisdiction, where the Crown was found liable for actually violating international humanitarian law by detaining and abusing prisoners of war. And I think that case is actually very, very important because it sets a limit to the operation of the Crown Act of State doctrine. And the High Court, namely Lord Legate, who was the High Court judge in that particular case, he said that the Crown Act of State doctrine cannot operate when a soldier acts under policy that violates international humanitarian law. So we actually already take into account international humanitarian law in the context of operation of tort law, but through the Crown Act of State doctrine. And one thing that Lord Legate said in that case is that acknowledging that a government decision to engage in a military operation abroad entails the use of lethal force does not require the court to accept that, for example, such lethal force may be deliberately targeted at civilians. What I think that Lord Legate is saying here is that if a British soldier deliberately targets a civilian, we obviously do not apply the Crown Act of State doctrine because this would violate international humanitarian law, and that's the limit to the operation of the Crown Act of State doctrine. But I think that he's impliedly saying we also shouldn't apply the combat immunity doctrine, and that it should operate under the same limits as the related Crown Act of State doctrine. If that is true, then I think we have an opening in English law to actually accept Haim's argument, because if international humanitarian law bars the operation of the Crown Act of State doctrine and the combat immunity doctrine, that opens the route for the application of general tort law in this field. Now, I don't want to sound like I'm criticizing Haim's book, because the purpose of Haim's book wasn't really to explain the English approach in this field. But I do think that highlighting some of these topics is important because it basically shows that we could probably implement Haim's approach if we look a little bit more widely, if we cast the net a little bit more widely than Haim did. And I think this basically opens up exciting new avenues for research. I would like to congratulate Haim one more time. He has written a truly excellent book. I think there are avenues of research that could be explored further, and I'm pretty sure that whoever explores those avenues will basically have to start with Haim's book as basically the key starting point. Thank you.
Perfect.
Well, they are.
Great. So first of all, thank you so much for all of these wonderful comments and the engagement. And of course, to Eden and everybody in KCL and HCL that helped getting this event happening and get everybody chatting about this book. And I'm very happy that it came out when it did, because a lot of things have happened over those 3 years that'll help refine and and change some of the arguments, some of the things I was thinking. So I think it's good that it came up in this time. And maybe I want to tackle a couple of things, a couple of themes from every speaker, because I know we're short on time. So the argument that I'm trying to make in this book is one that's trying to convince the staunch tort law people, corrective justice people perhaps, that even in the common law we can have a way in, we can have a way to think about why tort liability could and should apply even in the context of warfare and the heat of battle. And the way for me to try and frame this was, I think, very similar to what Ugljesa was just saying, that we can think about the context of warfare as a unique sphere, in both in terms of practicality, but also in normative terms. And we need to try and figure out why is it justified, or when can states explain how they can inflict certain losses on civilians. And we can try and think, okay, why are they allowed to do that? And that would be the starting point to try and figure out what could be a possible articulation of a wrong. And I go through various motions in the book to try and explain that exactly. But the argument that I'm making is that basically every infliction of a wrong on a civilian, any kind of injury, so loss of life, loss of property, any kind of trespassing person, that will be a prima facie wrong. But if they act in accordance with international humanitarian law and the rules of engagement, they have a justification, right? So there's a way in which to say, okay, that's justified. They acted with the right kind of authority. They haven't committed a wrong in that particular sense. But if they haven't, they infringe those things, then the same kind of ordinary principles could apply. There is no justification that would bar us from saying that that was wrong. We're not allowed to destroy people's property or injure them in any kind of way. That's true ordinarily, that's true in the context of warfare. We need to look at what's the source of authority that allows us to do certain things if we are to try and say that they're not wrongful. So that's the basic premise and the starting point. And I think in a way it talks about how Paula framed it as narrow. So I was trying to frame it as narrow in the sense that you have some people in the community that write about reparations for civilians, and they call for every injury for civilians to be grounding a cause of action or require remedy, and I'm not arguing that. And you have some people that say that obviously there should be no liability whatsoever under any circumstances, and obviously I'm not arguing that either. But I'm trying to talk to both of these audiences that usually don't talk to each other, so I think it's good to have this kind of range of people here, both in the panel and in the room, that can get to engage and think about these things. Because more often than not, you would see in court cases, judges explaining why tort law should apply. And I think today the longest case that I can think of that had any kind of in-depth theoretical treatment of it is the Coohey case. And it was one paragraph. So it's interesting that I needed to write a book to deal with the paragraph. And it took me about 10 years, but I hope that through this, we can try and start a conversation and think about what can be done and what we should resist, right? We should resist the idea that tort law doesn't apply in warfare whatsoever. And this was a challenge with the title. I wasn't sure about the word in, whether it should be something else, because we actually find quite a bit of tort law in the context of warfare. We find it in the context of false imprisonment and torture, just road accident. If you have a surgeon that did something wrong, if somebody constructed a swimming pool incorrectly and a soldier during recreational activities was injured, all of those things come in. So there's one case in the US about the contractor who installed toilets. So we can see that tort law is already present in a lot of meaningful ways in the context of warfare. And the question is, okay, what happens in the heat of battle? So I'm trying to deal with that and explain that a little bit. and to show that there are good reasons why we should think about tort liability as applying and how it could apply. And I think here comes kind of the nitty-gritty bits and kind of the quirks about it. So you're absolutely right that this was a theoretical project trying to draw on different jurisdictions and the experience from different places. And it's stretching the boundaries, right? This is a new argument. This is strange for a lot of tort law people because they think about any context of battle as something that tort law should imply, and yet it starts to face with the most extreme situations. So the question is, to what extent would tort people, or even if we think about Ministry of Defense people, politicians, to what extent would they have a buy-in? I think they should have a buy-in. They can have a buy-in, right? It's about the legitimacy. It's about the way in which we deal with accountability. It's about how soldiers would want to perceive themselves, how other countries would want to perceive us. And by framing the liability regime as one where you're not bringing a claim in your own court against a foreign nation, I'm trying to both deal with some doctrinal issues regarding sovereign immunity, but also to say this is ordinary accountability that apparently the Netherlands had for the last 30 years, and we don't know about it. So we should have, right? So it's good to know that there are other countries that are able to say, no, we're going to take accountability for our own actions for our purposes abroad. And when we try and think about, for example, the point about, I think both of you raised points about vicarious liability and intentional torts and the difficulties about it. Because this book is quite theoretical, trying to do something broad, we can see how different jurisdictions will have different reactions, and they have their own unique histories. But I'm hoping that it's not just going to be a stepping stone for a normative analysis, but also an opportunity to learn from other jurisdictions where some things have worked better, some things haven't. So there will be a way in which I'm not saying that vicarious liability shouldn't apply to intentional torts or we shouldn't have more direct liability. I say there are various ways in which we can overcome these challenges if we just open up our view and look around at what's happening. So, for example, if we think about vicarious liability, we can think about a lot of instances where, yes, theoretically, the state is held liable through vicarious liability, but in actuality, no individual public official was named. It was just assumed that this is the case, and the claim continued in that way. There are various critiques that we can say about that, but perhaps for another time, like you say, more projects. Excellent. We'll keep on working on that. So in a way, I'm hoping that I've tried to address some of the arguments, like the one that Paula raised about whether Smith was viewed as, is this too much and the duty is not realistic. Some people always think that, and I hope that other counter arguments about what we benefit from it can come in and chime in, but that is more of a political question than a normative one or even a policy one. So I'm hoping that at least there's ammunition against those kinds of arguments. So maybe I can just touch on Liesbeth's point about drones, right? What happens in drones? We're not even in the heat of battle. This is something that comes up quite a few times in the case law in Israel, where you had so many variations over the years and trying to think about exactly when tort liability should or shouldn't apply. And long story short, over the years, the immunity from tort liability in the concept of warfare has been expanded significantly. Interestingly enough, in the UK, it has been narrowed, unlike other jurisdictions. So that's an interesting change. But the point about looking at all the circumstances and try to really think what will be the implications for people on the ground if we expand liability. So I think instances like drone strikes are going to be, in some ways, classic instances where you won't have this kind of heat of battle argument that could be deterring. But what we do see in Israel case law, for example, where you had this kind of development, you had this shift, and nevertheless, immunity was expanded to include these types of cases, and to undermine the idea that the reason why we don't have immunity is because we're impacting the heat of battle, right? So there was a way of tying battle together, like this is something that is a unique situation that liability shouldn't be applied to. I don't agree that that is something that we can't necessarily think of or engage. But the way in which I articulate my arguments is that we have to try and look for the authority, right? The state's authority. So the question is not whether drone strikes are just generally things that should be susceptible to liability, but rather whether the authority to use these strikes, as much as we can say there is authority to strike in this way, has been done in the right kind of way, followed the right kind of procedure, has the right kind of authority being used to justify the results and therefore exclude wrongdoing, which I think ties neatly back to Ugljesia's point about thinking about the Crown active state, right? So in the Crown active state doctrine, there is this embedded thing that yes, there is immunity, but only as long as the authority was engaged in the right kind of way. And we don't see the exact same thing when it comes to combat immunity or the combat activity exception, or in the US, you have all sorts of other things like the foreign state immunity. So I think I think this would be a way of thinking about the limit of legitimate types of arguments, the limits of arguments that can justify immunity, or in a more slightly different way, to think about it this way. So far, it has been taken for granted that there should be immunity from liability. I want to say that we need to switch that way of thinking, right? We need to justify the existence of immunity and not vice versa. And if we do that, we have to justify it in the right kind of way, following the right kind of arguments. And if we fail to do it, then we need to think about what we do next, right? So yes, we can think about tort law. And Luca, I really like the point you said that before we had anything in international law, we had private law as the kind of the basis for international law and generally reparations, right? So it's good to go back to basics. It's good to use them to rethink what we have and where we might be going. And I think that a lot of times, maybe not explicitly, but implicitly, international law people tend to kind of peek over and say, hey, what's up, tort law? What are you doing? So I think it would be good to bridge that gap and start that conversation. I think it would be good in terms of accountability. I think it would be good for civilians, where we can hopefully help minimize some of the harm through mechanisms that, if not eliminate the wrongdoing to begin with, at least will give a way to vindicate some rights. So I'll stop there.